Ms. Wright, good morning, ma'am.
Good morning.
For the record, State of Tennessee versus Sherra, Wright, docket number 1705881. Mr. C. Faris Jr., Mr. Blake Allen are present for Ms. Wright. Mr. Austin Schofield, Mr. Paul Hagerman are present for the state. It's not a scheduled bond hearing today. All parties are present. There is a pre-trial bond report that has been submitted to the court. A copy of the report has been made available for all parties. And Mr. Ballard, Mr. Faris, this is Ms. Wright's motion. Do you have any additional proof that you want to submit on the bond hearing?
Judge, we, other than the information contained in the pretrial services report, we've talked to the state about not having a live witness here today. Her brother, Julius Robinson, was planning to be here today. We got caught in a meeting at work. His testimony would be simply that Ms. Wright is reliable to appear in court and that he could live with her here in Shelby County. I prefer not to put on the record that address. If the pretrial needs that, we can provide that, but the only additional proof above and beyond what's in this report would be that she would be living at home, in Shelby County with Julius Robinson, her brother.
Yes, sir. Mr. Allen, thank you. Mr. Hagerman, Mr. Schofield, any additional proof that the state wants to submit?
Two items, Judge. The first, and Your Honor has heard this, we read it to the record at Mr. Turner's bond hearing, is, for lack of better terminology, the affidavit of complaint.
Yes, sir.
In the case.
Yes, sir.
I can pass that forward, and I can read it again into the record if the court deems that appropriate.
Because it is a separate hearing from Ms. Wright, if you will publish for the record, Mr. Hagerman, what the probable cause is for the arrest and the indictment on Ms. Wright, please.
I will, Judge. Remember, this is lengthy, so I apologize.
Yes, sir.
July 19th, 2010, at 12:13 a.m., Germantown Police Department Dispatch received a 911 call. Several gunshots could be heard by the police dispatcher. The identity of the caller was not identified at the time, and the police did not investigate. On July 22nd, 2010, Lorenzen Wright was reported missing by his mother, Deborah Mary. Lorenzen Wright was last seen leaving his ex-wife, Sherra Wright's house, located at 4530 Whispering Woods, Collierville, Tennessee, on the evening of July 18, 2010. On July 27, 2010, investigators reviewed Lorenzen Wright's phone records and found that one of the last phone numbers dialed was to Germantown 911 at 12:13 a.m. on Monday, July 19, 2010. Investigators discovered that the 911 call from the unidentified person had been made by Lorenzen Wright. Investigators were able to determine the location where Lorenzen Wright had placed the 911 call and focused a search in that area. On July 28, members of the Shelby County Search and Rescue Team located Lorenzen Wright's decomposing body in a wooded field south of Calais Cutoff and west of Hacks Cross Road in Memphis, Tennessee. Lorenzen Wright appeared to have been shot multiple times. 9mm shell casings were scattered around his body, and 25 caliber shell casings were located also in the crime scene. The Shelby County Assistant Medical Examiner Marco Ross performed an autopsy upon the body, ruled the death to be a criminal homicide for multiple gunshot wounds. On May the 30th of 2010, Jimmy Martin contacted homicide investigators and advised that he had information concerning the murder of Lorenzen Wright. Homicide investigators interviewed Jimmy Martin, who stated that he did have a role in the murder of Lorenzen Wright. Jimmy Martin stated in the days before the murder of Lorenzen Wright, he was present during a meeting in which Sherra Wright, Billy Turner, and he planned the murder of Lorenzen Wright. Jimmy Martin also stated that an additional unknown person, later identified by investigators as Claudia Robinson, was also present during this meeting. The conspirators made a plan to murder Lorenzen Wright in either Atlanta, Georgia, in his home, or lure him to Memphis, Tennessee, and murder him there. Jimmy Martin stated that he participated in the planning of the murder with Sherra Wright and Billy Turner, and he received payment for this by Sherra Wright. Jimmy Martin is a cousin of Sherra Wright. Jimmy Martin stated that he rode with Billy Turner to Atlanta, Georgia. Jimmy Martin stated that during the journey, Billy Turner told him that they were going to Lorenzen Wright's house in Atlanta to murder him. Jimmy Martin stated that Billy Turner and he arrived at Lorenzen Wright's home in Atlanta, Georgia, and unlawfully entered the residence through an unlocked window. Jimmy Martin stated that Sherra Wright had visited the home in the days before their arrival and left the window unlocked to provide access for Billy Turner and him to enter the home and murder Lorenzen Wright. Jimmy Martin advised that once Billy Turner and he were inside the home, they observed an unknown male, who was not Lorenzen Wright, asleep on the couch. Jimmy Martin stated that this foiled the murder plot. Jimmy Martin stated that Billy Turner and he then slipped out of the house undetected and returned to Mississippi. The investigation revealed this occurred between June the 1st and July the 18th of 2010. Jimmy Martin stated in the days after the murder of Lorenzen Wright, he was picked up by Sherra Wright at his home in Batesville, Mississippi. Jimmy stated that Sherra Wright borrowed a metal detector from his mother, Edna Robinson, and then they left. Jimmy Martin stated that he rode to Memphis, Tennessee with Sherra Wright, where they picked up Billy Turner, and they confessed to him that they had murdered Lorenzen Wright. Jimmy Martin stated that he assisted Sherra Wright and Billy Turner in cleaning up the crime scene and destroying evidence from the murder. Jimmy Martin stated that the metal detector was used in an attempt to locate a firearm that was dropped during the murder. Jimmy Martin stated he accompanied Billy Turner to a lake located off Highway 72 in Walnut, Mississippi, where Billy Turner disposed of a handgun that was used to murder Lorenzen Wright. On May the 31st of 2012, investigators took Jimmy Martin to a lake located near 2491 County Road 302 in Walnut, Mississippi, and he showed investigators where he observed Billy Turner throw the handgun used to kill Lorenzen Wright. On June 27, 2017, the FBI Underwater Search and Evidence Recovery Team recovered Smith & Wesson 9mm semi-automatic pistol from that lake located at 2491 County Road 302 in Walnut, Mississippi, where Jimmy Martin had indicated that Billy Turner had thrown the murder weapon. The 9mm pistol was taken to the TBI for testing. On August 8, 2017, Special Agent Braswell microscopically examined cartridge cases from the 9mm Smith & Wesson in conjunction with cartridge cases that were located on the crime scene in the homicide of Lorenzen Wright. Agent Braswell determined that all 10 9mm casings from the crime scene had been fired from the 9mm Smith & Wesson handgun that had been recovered from the lake. Jimmy Martin identified Billy Turner from the photo lineup as one of the persons responsible for the murder of Lorenzen Wright. On November 13, 2017, investigators interviewed Edna Richardson, and she confirmed that in the days after the disappearance of Lorenzen Wright, Sherra Wright had come to her home in Batesville, Mississippi. Edna Richardson stated that Sherra Wright borrowed her metal detector and her son Jimmy Martin left with her. On November 15, 2017, investigators interviewed Claudia Robinson. Claudia Robinson stated that in the days before Lorenzen Wright was murdered, she was present during a meeting between Sherra Wright, Billy Turner, and Jimmy Martin. Claudia Robinson stated that she observed Sherra Wright, Billy Turner, and Jimmy Martin plan the murder of Lorenzen Wright. Claudia Robinson advised that during the meeting, Sherra Wright, Billy Turner, and Jimmy Martin planned to kill Lorenzen Wright either at his home in Atlanta, Georgia, or in Memphis, Tennessee. Claudia Robinson identified Sherra Wright, Billy Turner, and Jimmy Martin from photographic lineups as the persons that she observed planned the murder of Lorenzen Wright. On November 16, 2017, investigators interviewed the cousin of Sherra Wright, Amanda Crenshaw. Amanda Crenshaw stated that she was riding in a car with Sherra Wright the day before Lorenzen Wright's body had been found. They were stopped at a traffic light at Hacks Cross in Winchester and were discussing the disappearance of Lorenzen Wright. Amanda Crenshaw stated that Sherra Wright pointed toward an area and stated he was probably dead in a field over there. The next day, Lorenzen Wright's body was found in the area where Sherra Wright had pointed out. Amanda Crenshaw also stated that Sherra Wright and Billy Turner were involved in a sexual relationship during the time of the murder of Lorenzo Wright. After the murder, investigators dumped the contents of Sherra Wright's cell phone. On July 17, 2010, Sherra sent a series of sexual text messages designed to lure Lorenzo Wright into Memphis, Tennessee. On July the 18th, 2010, Lorenzo Wright flew to Memphis, Tennessee, and met Sherra Wright at 4530 Whispering Woods, Collierville, Tennessee. Lorenzo Wright left the home around 11:30 a.m. and was murdered shortly later at Hacks Cross and Filet Cutoff in Memphis, Tennessee. Phone records indicate that Sherra Wright, Billy Turner, and Jimmy Martin communicated both before and after the criminal homicide of Lorenzo Wright. Sherra Wright received an insurance benefit of $1 million for the death of Lorenzo Wright. On November the 7th, 2017, investigators obtained a court order by Shelby County, Tennessee Criminal Court Judge Division 6, Judge John Campbell, authorizing the interception and the monitoring of wire communications with Sherra Wright and Billy Turner's cellular devices. On November 7th, investigators began monitoring communications. On November 9th, 2017, investigators released information to the media that the gun used in the murder of Lorenzo Wright had been recovered by police. During the interception of Sherra Wright's communications, police learned that Sherra Wright heard about the police finding the gun used in the murder of Lorenzo Wright. This information caused Sherra Wright great stress. In a call, Sherra Wright stated, "Someone done sent somebody somewhere to get something," indicating that the police were talking to an informant. In another call, police learned that Sherra Wright planned an unexpected trip from California, where she now resides, to Memphis, Tennessee, to, quote, handle some business. On November 11, 2017, Sherra Wright flew to Memphis, Tennessee. On November the 12th, 2017, at 9:37 a.m., Billy Turner received a text message on his cellular phone from a phone utilized by Rosalind Coburn that stated, "I'm on her phone. I got a chance to see everybody but you this morning. This is your sis from Cali." Billy Turner appeared not to recognize the phone number and replied, "Wrong person." Billy Turner then received another text from the phone that stated, "Boy, that's Sherra on my phone." Several text messages were then exchanged as Billy Turner asked how long she'll be in town. Billy then receives a text message from the phone saying, "A couple days, you should eat at, quote, TJ's. Shortly later, Billy Turner places an outgoing call to Janice Taylor, believed by investigators to be TJ. Janice Taylor then puts Sherra Wright on her phone. During the conversation, Sherra Wright tells Billy Turner that she wanted to show him something, and they agreed to meet at Janice Taylor's house. Investigators recognized this meeting was arranged using third-party phones in an effort to conceal their contact from phone records. Investigators conducted surveillance at the home of Janice Taylor at 483 Starlight, Collierville, Tennessee. On November 12th at 2:32 p.m., investigators observed a meeting between Billy Turner and Sherra Wright. Covert photos were taken of the meeting. On November 27th, investigators monitored a call between Sherra Wright and the mail. Sherra told the mail that when the police searched her house in Collierville, they missed 3 guns hidden in her house, and the guns were given to her. During the early stages of the investigation, the police did execute a search warrant at Sherra Wright's home. On November 28, 2017, investigators interviewed the sister of Billy Turner. Investigators advised Sherry Turner, the sister, that they were investigating a criminal homicide of Lorenzo Wright. Investigators asked Sherry Turner several questions in an effort to establish the activities of Billy Turner in the days before the homicide. Investigators also asked Sherry Turner and Billy Turner possessing firearms. Later that day, investigators monitored a call between Billy Turner and an unknown male. Another conversation between Billy Turner and Sherry Turner could be heard in the background of this call. In the conversation, the female told Billy Turner about the interview she had with investigators. Billy Turner asked the female what the police had said. The female replied that they had asked her where Billy Turner's gun was. The female then tells Billy Turner, "You better hide that gun." 2 thumps are then heard, implying a violent reaction from Billy Turner. Billy Turner then said, "Shut your mouth," can be heard whispering either, "I'll shoot you" or "I'll shoot you too." On December the 5th, 2017, investigators executed a search warrant in the home of Billy Turner. Inside the bedroom, they found documents and ID indicating that it was Mr. Turner's bedroom. Investigators seized a 12-gauge pump-action shotgun, as well as another firearm from the house. I guess that's a relevant portion of the affidavit as it goes to Ms. Wright.
So,
Pass that forward, Your Honor.
for the record, this is a six-page document. Probable cause affidavit for the arrest and indictment of Sherra Wright. Will have submitted Exhibit A to the bond hearing. Exhibit A is an apple. Will order that the affidavit, the arrest probable cause statement be placed under seal. Exhibit A. Hager, say this is have an additional proof that you want to submit to the bond hearing.
One more exhibit, Your Honor. This is a collective exhibit. This is a series of 6 incident summaries, is how it's titled. And it has to do with times that Mr. Wright has been cited, written up, disciplined during her incarceration at jails. I'm not going to read each and every one of these into the record, but begins on March the 12th, infraction for passing items to another inmate underneath the door, which is an infraction at Jail East. Similarly, on March 19th, a similar incident where she's passing items to another inmate. Similarly, on March the 30th, where she's passing items to another inmate. And then yesterday, May 29th, where she's passing items to another inmate. And then 2 more incidents from yesterday. One includes her being unclothed in her jail cell and flooding her cell, flooding part of the pod. And then the final incident from yesterday, late afternoon, after she attempted to flood the pod, in which she exclaimed, made derogatory statements, incendiary statements to officers, and caused a verbal, for lack of a better word, I guess, riot in her pod area. We got these 6 that we can mark as collective exhibit from Jail East.
So now, Mr. Reese, have you had a chance to review these documents?
Yes, sir.
For the record, these are 6 incident summaries from infractions that Ms. Wright has incurred allegedly since she's been housed at Jail East for women. A total of 12 pages. Court will admit this is Exhibit B as in boy collectively, and this will also be ordered to be placed under seal. However, Mr. Schofield stated Tennessee have an additional proof to submit at the bond hearing.
That would go to the state's proof.
Counsel, approach, please.
One I had, I lost it.
Mr. Ballin and or Mr. Parisi, the statements or arguments regarding the bond in this case.
Julie, we do have an argument, and being here for a bond hearing means that we're looking at TCA 4011-118, which lays out 8 or 9 factors that the court needs to look at in determining a reasonable bond. And of course, the statute starts out by indicating that the bond shall be set as low as necessary to assure the defendant's appearance and protect the safety of the public. So that's sort of our main purpose here. And then, of course, 4011-118 lays out those factors. And I just want to go through those and talk about how they apply in this matter to Ms. Wright. The first has to do with the length of residence in the community. And of course, somebody who's been here longer has more ties to this community and is more likely to stay here and appear in court. According to the pre-sentence report, pretrial services report, Ms. Wright is 47. She has lived outside of Shelby County for a total of 3 years, which was a law school, so I'm not great at math, but I think that means that she's lived in Shelby County for about 44 years. So we would submit that factor number one weighs in favor of a low and reasonable bond. Her employment and financial condition, she was self-employed, trying to make ends meet by cleaning houses while she was in California. Her financial condition, as indicated in the affidavit we submitted earlier, is that she's indigent. So any amount of bond that is set for Ms. Wright will be a high one, because she simply doesn't have the funds and will be relying on others to help post the bond if a reasonable bond is set. Her family ties and relationships. Of course, she most recently was living in California and Texas before that. She does have quite a few family members in Memphis. Julius Robinson, her brother that we referred to earlier. She has another sister, Katrina Robinson, in Memphis. Extended family, including her stepmother, aunts, uncles, cousins. They all live here in Shelby County. So although she recently was living outside the jurisdiction, she still has extensive ties to this community. Her reputation, character, mental condition. Really the only information in this report that has to do with that comes from her son, Lorenzo Wright Jr., who verifies that the information she gave is correct and that she's reliable to keep future scheduled court dates. The information that was submitted to the court about her institutional history, the write-up she's had, I think it's important to note, first of all, that whatever items were passed, and on information and belief, those items were food items that were passed. They were not contraband. If they were, that certainly would be in the reports. The other incident that involves the flooding of the cell, if anything, speaks to her deteriorating mental health. So I think that's the only real factor here. She's not fighting in jail. She's not being caught with contraband. Again, if anything, the rules that are being broken indicate that perhaps there's a need for some sort of mental health counseling here, an issue that we would submit can be dealt with while she's out on bond. Her prior record is important for two reasons, and it falls under two different factors. The first has to do with her prior record and how that plays a role in her reliability, whether she's going to appear in court. Prior record consists of 2 driving on suspended license charges from over 20 years ago. There was a bench warrant issued back in 1996 that appears to have been immediately taken care of within 30 days, and she ultimately was fined. Beyond those 2 fines that she's paid for driving on a suspended license, she has absolutely zero criminal history. So we would submit that under this factor, nothing about her criminal history indicates that she would not be reliable to come to court. I want to skip to the 7th factor under this statute, which also looks at her prior record, but from a different angle. It talks about her risk of danger to the community. And this is where there's a stark contrast with Mr. Turner, who not only had other cases pending, was found with firearms despite being a convicted felon. He had a violent history, and I assume that was a big factor in setting such a high bond for Mr. Turner. In contrast, Ms. Wright has no criminal history indicating a violent nature. And importantly, the charges that we're here about today, because she's innocent until proven guilty, these were not part of the calculus under the statute. It has to do with prior record. And although she's charged with being involved in a violent offense in court today, that is not, again, the type of prior record that is to be looked at under the statute. So there is absolutely no reason, based on her prior record, to believe that she is a risk of danger to the community. The identity of members of the community who will vouch for her reliability. Again, we go back to Julius Robinson and then to her son, who was interviewed for the the pretrial services report. And then the final factor here, and it's an important one, obviously, has to do with the nature of this offense and the likelihood of conviction. Obviously, being charged with first-degree murder, it doesn't get more serious than that. And the state has read to you an affidavit or a probable cause statement. They leave some things out. And I think it's important, while we're not in trial here today, it's important to know about some of the things that were left out of this probable cause statement, because they've told a really tidy story, and it's a bit more of a mess than they've let on. This morning I was looking over some of the discovery, specifically focusing on what I believe to be the foundation of their case, and started thinking about that word foundation. Building a house, you want a strong foundation, concrete, but this is a case that's built on a bed of sand. And when you start to dive into the evidence and look at Jimmy Martin's history, look at the statements he gave, you realize that this case is not built on the steady foundation the state wants you to believe it's built on. Mr. Martin, of course, we know is a convicted murderer, and he's a liar. He is somebody you wouldn't trust to walk your dog around the block. He has given multiple statements to law enforcement over the years, self-serving statements that limit his involvement. He has given inconsistent statements, and these are just a few of the things I picked out looking through it this morning. He originally denies even knowing Billy Turner. But then when he's confronted with some other information, he admits that he lied. He, at one point, talks about there being multiple guns thrown into a lake. He, at another point, says there was one gun. He claims at one point that he got absolutely nothing for his involvement in this circus, and at another point he says he was paid. His description of these meetings that took place, they differ. The number and identities of people who were there. He, at one point, says there are three people at the meeting. At another point, he says there are 4. He can't identify one of these people. He is simply not a believable person. Claudia Robinson, they told you today what her statement was. What they didn't tell you was that when she was initially approached by law enforcement, she told a completely different story, denied all knowledge, denied involvement, denied knowing anything, and at some point decides to change her story, whether she was confronted with, here's the evidence, here's what we want to hear by the police, whether she was threatened with some sort of criminal liability before she told the officers the story they wanted to hear, I don't know. But again, what the state didn't tell you this morning was that she also has not told the truth every time she's had the opportunity to. So while, again, this is a serious case, and again, the most serious charge that can be brought in this state, the state's charges are not built on the strong and steady foundation they want you to believe. And for that reason, taking all these factors into consideration, we believe that a $100,000 bond would be sufficient.
Thank you, sir. Mr. Hagerman.
There's one thing I want to correct to start. Sherra Wright is here. We're not here to set a bond on a violent offense. She's here on 3 violent offenses. She's charged first with conspiracy to commit first-degree murder, planning the murder of Lorenzo Wright. And for Miss Wright, that carries 25 years in jail. She's here accused of sending 2 armed hitmen, her boyfriend and her cousin, to Lorenzo Wright's home in Atlanta, Georgia, to go in there first and leaving the window unlocked to kill Lorenzo Wright. Attempted murder. For Miss Wright, that carries 25 more years. And then she's here for actually killing him, along with Billy Turner. And for Miss Wright, that carries life in prison. So Miss Wright is facing not a violent, serious offense, but 3 violent, serious offenses that for all intents and purposes carry 2 life sentences for her. So that's the severity of the offense, and that's her exposure at a trial or a guilty plea. The proof in this case, and I've heard Mr. Ballin and before Mr. Perry talk about Jimmy Martin. Your Honor heard from the affidavit that this case, especially the case against Ms. Wright, isn't built on the testimony of any one witness. Yes, Mr. Martin was there, conspired with her, went to Atlanta with Billy, can provide an eyewitness account of her involvement, and he's her family member. But his testimony is also corroborated by huge physical evidence. A lake in Mississippi, where at the bottom of it sits a firearm for years and years and years. And when it's finally recovered, it matches what? Every 9mm shell casing right there around the body of Lorenzen Wright. Jimmy Martin can and will be dragged through the mud. He's a convicted murderer, a bad person, but corroborated by a gun in a lake that was there for 7 years and matches every single shell casing. Beyond Jimmy Martin, the eyewitness testimony of her cousin, Claudia Robinson, who sat there in a room with Jimmy Martin, with Billy Turner, with Sherra Wright, and planned the murder of Lorenzen Wright. That's 2 eyewitnesses right there who saw it, who lived it, who breathed it. Circumstantial proof, a mountain of circumstantial proof outlined in the affidavit. Secret meetings, her reaction to the murder weapon that was found over the phone, taped phone conversations, travel from California to Memphis, unexpected and secret, using other people's phones to arrange a meeting with code, TJs, Edith TJs, during this investigation after the gun is found. This is not a case built on one witness, but a case built on 3 or 4 or 5 even different kinds of proof. Direct proof, corroborated direct proof, circumstantial proof, secret meetings, surveillance photos, recorded conversations. I'd ask the court to find that the likelihood of conviction is high, that the strength of this case with regard to Ms. Wright is great. Does she have ties to Memphis? Well, in the past. When she was arrested, she was living in California. Also at some point in Texas. Just during the facts of this case as outlined in the affidavit, you heard how she traveled from Memphis to Atlanta and from California to Memphis. There's all those things. And I was prepared to come in here and argue those things and ask Your Honor to set a bond for Ms. Wright that was appropriately high given the likelihood of conviction, given her risk and exposure of 2 life sentences in this case, given the fact that she is not a resident of Memphis, Tennessee. I was prepared to come in here and ask Your Honor for a high bond, for a $10 million bond. But then, what do we hear? How did Ms. Wright prepare for this bond hearing yesterday? Can you trust someone on bond who in jail the day before her bond hearing is sanctioned not once for passing contraband, not a second time for stripping her clothes off, flooding her cell, getting confrontational with officers, flooding the pod, and refusing to comply with the demands of staff. But then a third time, being directly confrontational, and Your Honor can read for yourself what she said to the guard, what her taunt to the guard was, directly confrontational with the guards. 3 times on the eve of this, her bond hearing. One of the factors that Your Honor is to consider by statute is the mental condition. Those things speak to that, but they also speak to her unwillingness, her refusal to comply with rules and restrictions, even when she's in custody. Even when she's in custody. Can someone like that be trusted out in this community on bond for three violent, serious offenses that carry 2 life sentences and that are based on proof of multiple eyewitnesses, circumstantial proof, corroborated proof, recorded phone calls, and covert meetings? I'm not sure even a $10 million bond is high enough to cover that.
Mr. Allen, Mr. Stories and additional statements or arguments?
No, Your Honor.
And for the record, the court has considered all those factors between the Tennessee Code annotated 40-11-115 and 40-11-118. In our law, Tennessee Code annotated 40-11-102 would require that before trial, all defendants shall be bailable by sufficient sureties, except for capital offenses where the proof is evident and the presumption is great. In this case, the state's file has indicated would not seek the death penalty in this case, would not seek life without the possibility of parole, rather to discuss this matter with family members, Ms. Deborah Marion. And if Ms. Wright is convicted of first-degree murder, the court has to sentence Ms. Wright to life confinement. Life in the current Tennessee law is construed to be 60 calendar years in prison. Ms. Wright is not eligible for parole. She can be released after serving 51 years of that sentence. She's also been indicted for criminal attempt to commit a felony with first-degree murder and also conspiracy to commit first-degree murder. She would appear to be a rank 1 offender. If she's convicted of those offenses, it carries a minimum of 15 to as much as 25 years in prison. If the state were to file a motion, if the court found that a sentencing hearing that these sentences should be ordered to be served consecutively, Ms. Wright is looking at life plus 50 years in prison. As Mr. Harry was indicated, essentially 2 life sentences, as life is construed to be 51 calendar years before a person is eligible for release. Tennessee Code annotated 40-11-115 actually presumes and mandates that the court shall consider an ROR bond, and the court shall set a bond no higher than that necessary to accomplish the purposes of the Tennessee Bail Reform Act. And 40-11-115 requires this court to consider an ROR bond on a case if any person is charged with a bailable offense, and this is a bailable offense to say it's not seeking a death penalty. The court shall consider whether or not a person could be released on his or her own personal recognizance without having to post a monetary bond. This court, there are several factors the court has to consider under 40-11-115. That includes the defendant's length of residence in the community, employment status and history, family ties and relationships, reputation, character, mental condition, prior criminal record, including prior release on recognizance or bail, an identity of any responsible members of the community who would vouch for the defendant's reliability as far as reporting to court, the nature and offense and apparent probability of conviction, and the likely sentence, insofar as these factors are relevant to the risk of non-appearance, and any other factors indicating the defendant's ties to this community. The bond hearing that we had on Billy Turner about 4 weeks ago, Mr. Perry made a statement that he had studied the court's history and set in bonds, and I don't know what history Mr. Perry has frankly been looking at, because I follow the law to its logical and sometimes illogical extremes. People may sometimes take exception to the rules that the court makes, but that's what the Court of Criminal Appeals and Supreme Courts are for. And if those courts believe that the court has followed inappropriate standards, they will let me know. I'm very proud of the history this court has and cases that have been handled on appeals and things have been reversed and sent back to this court. You can count on one hand. Since I've been on this bench for 12 and a half years, you count on one hand sometimes the appellate courts have sent back something to this court and said, Judge Coffey, you might want to reconsider that ruling. We actually had a case in the court about 2 weeks ago, 17, 16, 15-year-old child that was sent from juvenile court with a no bond set on a case involving home invasions and kidnappings and aggravated robberies and special aggravated kidnappings. And this court released that young lady on her own recognizance. that case had a no bond was set. And I consider the factors that the court has to consider, just as I will in this case and in all other cases. And this is not a case that Ms. Wright should be considered to release on her own recognizance for a personal recognizance bond. And having considered that this is not an appropriate case for personal recognizance bond, the court has to consider under 4011-116 whether there are any non-monetary conditions of release that the court could set. Non-monetary conditions of release, considering those same factors that the court has considered, including possibilities of electronic monitoring, curfews, house arrests, drug treatments, and other alternatives or non-monetary releases. And again, for the reasons that I will state shortly, this is not a case that the court feels that releasing Ms. Wright on a non-monetary release bond, conditions of bond would be appropriate in this case. This court finds that a bond shall be set pursuant to 40-11-117 and pursuant to 40-11-118, the court, there are two components. And 40-11-118 says the court shall set a bond no higher than that necessary to accomplish the purposes of the Bail Reform Act. And at the same time, to make sure the defendant will reasonably appear in court, the court has to consider what bond shall be set to make sure that the safety of his community is in fact protected. Ms. Wright is essentially, with the exception of the last 4 or 5 years, is essentially a lifelong resident of Memphis and Shelby County, the immediate area. She's 47 years of age. This report indicates that she stayed in California for 6 years. We'll note for the record that we had to extradite Ms. Sherra Wright from California. Took a while in order to get Ms. Wright extradited from California. And we'll note that for the record, take public notice of that, judicial notice of the fact that Ms. Wright was in fact arrested in California and had to go through an extradition process before she ultimately waived her rights to be brought back to Shelby County, Tennessee. But it did take some time to go through governor's warrant in order to get Ms. Wright back in Shelby County, Tennessee. She has resided in California, according to this report, for 6 months prior to her being returned to Shelby County with a husband, Timothy Robertson, Robertson. And before that, indicated she lived in Sugar Land, Texas, with her children for 2 years. And before that, indicated she lived in East Tennessee with a husband, Reginald Robinson, Robinson. She did attend Grand Canyon University. Indicated that she completed 16 years of school. It indicates that she's been self-employed for the last 5 years. Mr. Valen indicates that she essentially is indigent and has been cleaning houses for the last few years. And this court does find that other than those 4.5 years or so where she was not living in Shelby County, that she does appear to be a lifelong resident of the Shelby County area. This court has also considered her financial status or ability to post the bonds. Ms. Valen indicated almost any bond in this case would essentially be a no bond because Ms. Wright does not have a wherewithal to post this bond. The court did, in fact, declare Ms. Wright to be indigent for purposes of investigation on this case. She does not appear to have a financial ability to post a bond on this case. This court also has to consider her family ties and relationships. She does have a brother who lives in Shelby County, Tennessee. Mr. Julius Robinson, and Mr. Valen has indicated she will reside with Mr. Robinson should this court set a bond that she is able to make. She does appear to have significant family ties and relationships, not only in Shelby County, but in other areas. The information contained in this report was verified by her son, Lorenzo Wright Jr., who indicates that he believes that his mother is reliable to keep future court dates upon posting bonds. This court has to consider reputation, character, and mental conditions. And I will summarize this for the record because it's indicated by Mr. Hagerman some things in these incident summaries that caused the court some concern. Would not publish all of this, but Ms. Wright had 3 incidents yesterday on May 29th, 2018. The day she was scheduled to be in court, the day before she was scheduled to be in court. Some of the other incidents, as Mr. Valen indicated, involved maybe passing food to other inmates is not something that the court puts a lot of emphasis on. But 7:55 yesterday morning, she had an incident for apparently passing items to another inmate, which is a violation of the institutional policies of the Shelby County Division of Shelby County Jail East. And at 15:49 rather, 3:49 p.m., she's involved in another incident in which she's allegedly engaged in cursive, disruptive behavior, abusive, profane language towards security guards at Jail East, making some comments that are frankly, if true, are shocking. Things that should not be published, should not and will not publish it. What she allegedly calls some of these inmates, because it should be embarrassing to Ms. Wright. It is embarrassing to this court. This court will not publish what Ms. Wright called some of these folks, but using profanity, words that we've become somewhat commonplace to, calling folks allegedly a bitch, quote, but also other offensive, absolutely offensive language that there is no place for that language if this is in fact true. Shelby County Jail East in the case of Ms. Wright is disrespectful to the staff. She refuses orders while she is in custody. She engaged in a disrespectful rant and slowly complied with those orders after they began to tell Ms. Wright that she continued to yell vulgar obscenities at the staff members, that they would have to use some chemical spray in order to get her to comply. And at some point she did in fact comply. Some 6 minutes later, at 15:55 p.m., 3:55 p.m., they're back engaged in other incidents with Ms. Wright, allegedly where Ms. Wright has taken off her clothing, has tried to stuff a toilet, tried to flood a toilet, and was making some comments that she is going swimming, y'all. And that goes directly towards her mental state or mental conditions. Mr. Ballins indicated that perhaps it shows that she has some deteriorated mental issues that might be best treated while on bond rather than in custody. And those things are troubling, and it does go towards her mental health or her mental conditions. If Ms. Wright is taking off clothing, refusing to put on her jail clothing, was allegedly running around naked, trying to flood a toilet, and telling the people at Jail East that she's going swimming. Something is not right if those things are in fact accurate, and the court does find that her mental condition, her character are reflected negatively by the abusive language, by the cursive language, by the derogatory language in which she refers allegedly to these deputy jailers out of Jail East, and by her telling these folks that she's got naked because she's going swimming. There is a disconnect that causes this court some concern. The court also has to consider Ms. Wright's record of appearance in court as to whether or not she appears to be a flight risk. She has been given citations twice in the mid-90s, 1995 and 1996, had one bench warrant that was issued. She ended up paying a $110 fine for driving her license revoked, canceled, or suspended, and a $250 fine for driving her license revoked, canceled, suspended, and apparently $275 fine for reckless driving. So criminal history is not extensive, has no great record of criminal convictions, three misdemeanor convictions. She has one instance in which a bench warrant had to be issued for her to arrest. So she does not appear necessarily to be a flight risk. The court also has to consider the nature of the offense and apparent probability of conviction and the likely sentence if Ms. Wright is in fact convicted. Ms. Ballin and Ms. Farices indicated that they believe that the state's case is built on a foundation of science. Does not believe that this is a solid foundation, believes that the proof in this case, the witnesses have given inconsistent statements, have given contradictory statements over the years. Jimmy Martin is in fact a convicted felon, having been convicted of second-degree murder. And when the court, if this case, and when this case is tried, when a witness, before a witness is allowed to testify, a witness raises his or her right hand if they swear on a Bible to tell the truth, the whole truth, and nothing but the truth to help them God. The law, and what I tell a juror, I'm required to tell a juror, that the law presumes that once a witness has taken that oath, that that witness in fact will in fact tell the truth. The law presumes that once a witness has been sworn to tell the truth, that the witness will in fact tell the truth. The law also presumes will tell a jury that if there are inconsistent statements, the jury must reconcile those statements if they can without rashly or hastily concluding that a witness is sworn falsely, because again the law presumes that those folks will tell the truth when they tell the truth. These statements that have been given outside of court are not sworn statements. Those are not statements made under oath, under the penalties of perjury, and it's frankly not a crime, unfortunately, to talk to police officers and not tell police officers the truth and to tell them different versions of the truth. That is not necessarily a crime. But when a person comes to court and takes an oath to tell the truth, the law presumes that person will in fact tell the truth. The law also would tell the jury they can believe some, all, or none of what a witness says. And this is a finding that the court has to make by preponderance of evidence, not by clear and convincing or not by proof beyond a reasonable doubt. As jury's verdict, in order to return a verdict on this case, the jury has to make these decisions beyond a reasonable doubt, but by a preponderance of the evidence, it does appear to be a reasonable likelihood of conviction in this case. This case, based on what is before the court, is not necessarily grounded only on Jimmy Martin's alleged testimony. It is also grounded on other family members in which allegedly Ms. Wright and others, Jimmy Martin and Billy Ray Turner, sat in a living room of Claudia Robinson, and when this alleged attempted murder and the actual murder was planned of Lorenzo Wright. These are family members of hers. Mr. Martin is a family member of hers, and Amanda Crenshaw, also a family member of hers, allegedly the day before the body was found, is riding with Ms. Wright, and Ms. Wright tells Amanda Crenshaw that that's where she believes that Lorenzo's body will ultimately be found. Those are circumstantial evidence. What the court tells the jury is that there's no difference in the weight that a jury can give circumstantial and direct evidence. Both are considered of equal value under the law. Mr. Martin is of the criminal element. He is a convicted felon. He is arguably a party to at least the attempted murder and the conspiracy to commit murder. He's not, if a jury believes what he's saying, he's not a party to the actual killing. But Ms. Wright cannot be convicted solely on the uncorroborated testimony of Mr. Martin if a jury finds that he is in fact a party to this offense. Arguably, he's not a party to the homicide if he says he's not present but was present, did carry out a plan to try to kill Lorenzo Wright, was not present when the actual homicide took place. Not a party to the homicide, but this testimony would have to be corroborated by other facts and circumstances, including some facts and circumstances that go to the identity of Sherra Wright. But there does appear to be a preponderance of evidence of reasonable likelihood of conviction. Again, this is not a trial, but based on what is before the court, it does appear to be a reasonable likelihood of conviction based on the apparent probability of conviction of the preponderance of evidence that is before the court. And again, the likely sentence in this case would have to be life at a minimum, and life plus 50 years if the court found that these sentences shall be ordered to be served consecutively. The court also finds that she does have family support, locally and otherwise, and folks that have in fact told the court that she will in fact appear in court. But appearance in court, or her appearance in court, is just one of the factors the court has to consider. The court has to consider whether or not Ms. Wright is in fact an ongoing danger to Shelby County, Tennessee. These are three separate crimes, as Mr. Hagerman's pointed out. This is not a homicide of Lorenzo Wright. These are three separate crimes in which Mr. Wright is a victim of a conspiracy in which people sat around and plotted his death. He's a victim of an attempted murder where folks traveled to Atlanta, Georgia, allegedly to kill Mr. Wright, but found another unknown, unsuspected person in the apartment, did not carry out that homicide at that point. And then the actual killing itself, in which a gun that was allegedly used to kill Lorenzo Wright is discovered in a lake. It's tested by the Tennessee Bureau of Investigation, and all recovered shell casings, according to the Tennessee Bureau of Investigation, were all fired by this gun that Mr. Martin led members of law enforcement to in a lake in Mississippi. If this were federal court, and I will continue to say this, if this were federal court, and most states in the United States of America, if a court makes a finding, and I make this finding for the record, there are no combinations of bonds. no conditions, no non-monetary conditions of bond and bond itself that this court could set that would make sure that Ms. Wright is not an ongoing danger to Shelby County, Tennessee. When she has been locked up in jail, Ms. Wright has demonstrated conclusively, allegedly, that she is still an ongoing danger to Shelby County, Tennessee, even when she is incarcerated. Allegedly cursing out deputy jailers, allegedly threatening deputy jailers, allegedly making remarks to these folks that are so foul, so offensive, so incendiary that I would not even publish those statements in the courtroom. But if she's acting that way while she is in custody, safekeeping, she is removing her clothing, vandalizing government property by flooding or trying to flood toilets, and making a statement that she is going swimming. Ms. Wright does appear to be an ongoing danger to Shelby County, Tennessee. And again, these are three separate offenses that occurred over a several month period of time. This is not one isolated incident in which a person is killed and this is over with. This is the planning. It was a conspiracy to allegedly kill Lorenzen Wright, the failed attempt to kill Lorenzen Wright. And finally, Ms. Wright lured, allegedly, Mr. Wright back into Shelby County, Tennessee, where was ultimately killed as a result of multiple gunshots and at least 2 guns allegedly been fired. If this were in federal court, and in most states, if a judge finds that there are no non-monetary conditions of bond, and bond or combinations of the two that will protect this community, if a judge finds that by preponderance of evidence that it does appear to be a reasonable likelihood of conviction, if this were in federal court, Ms. Wright would simply be detained without a bond being set. I would urge the legislature, urge our appellate courts to give trial judges that discretion in state courts in Tennessee to set on violent cases where it appears to be a reasonable likelihood of conviction, give trial judges the ability to simply say Ms. Wright will be detained without a bond. If this were federal court, that would be the finding. And in federal court, it's a higher standard. The court would have to find by clear and convincing evidence in order to detain a person. In state court, the threshold is a lot lower. It's simply by preponderance of evidence. And I do find that there are no combinations of bond and non-monetary conditions of bond that can protect this community. Not only while Ms. Wright is on the street, but while she is in custody. And that is something that the court grants great deference to in this case. It is absolutely shocking and mind-numbing. The affidavit that I just read from what Ms. Wright did in jail yesterday, knowing she had to come to court today and say, Judge Coffey, will you please set a reasonable bond? And I promise that I will comport myself civilly and I will not engage in anything else that might be against the laws of the state of Tennessee. She's engaged in a conduct in jail that is, in fact, against the laws of the state of Tennessee and against the laws of humanity. Some of the statements that she allegedly called some of these security deputies are absolutely horrific and absolutely shocking. They're absolutely horrifying. And I cannot believe that Ms. Wright allegedly some 15 hours, 16 hours before she's scheduled to come to court is engaged in conduct that is not only antisocial, not only offensive, not only abhorrent, but is also criminal. And this court finds, taking all those things into consideration and understanding this balanced statement that Ms. Wright is different from Willie Ray Turner, that Ms. Turner is in fact a convicted felon, and Mr. Turner has other indictments charging him with being a convicted felon in possession of a firearm. Mr. Wright, Mr. Turner has indicated earlier, was still engaging in criminal conduct since these offenses, as is Ms. Sherra Wright, is still engaged in antisocial and criminal behavior since she's been locked up in jail. Ms. Wright is allegedly the person that coordinated this. She's the person that orchestrated this. Ms. Wright is the mastermind behind the killing of a person, killed for, apparently, according to what we read in the record, they killed for insurance policy. And Ms. Wright is the person who led to the killing of Lorenzen Wright. She is, according to what is before the court, the linchpin. And but for Sherra Wright, Lorenzen Wright might still be alive. This court finds that the bond in this case shall be set to cover this indictment at $20 million for the reasons he stated. Ms. Wright's behavior yesterday is absolutely shocking to the consciences of this court. Those documents will be placed under seal in the event of any appellate review, and I'm sure that the Court of Criminal Appeals and the Supreme Court read what the court just read. They will be as repulsed as I am. They will find it as repugnant as I did, because those statements are simply should not happen in a civilized world. Those statements should not be published against anybody. And if those things are true, as Mr. Ballin indicates, it might go to show that Ms. Wright has some deteriorating health issues or mental health issues. I don't know, but something is not right when this kind of behavior allegedly occurs some 17, 18 hours before Ms. Wright is supposed to be in court. Say, just call me, you trust me on the bond. I cannot trust Ms. Sherra Wright, because I cannot trust her to act properly while she is in custody. With no deception for the record, Mr. Reese and Mr. Ballin. Mr. Hageman, Ms. Schofield, and Mr. Reese and Mr. Ballin, we need a report day.
Yes, sir.
Madam Clerk. Is July 10 a good day for all? I'm sorry. July 12 a good day for all lawyers?
I'm good with that, Your Honor.
For the record, we show this case set on July 12th for report setting. We'll also show Billy Ray Turner's case set on July 12th for a report setting also. Ms. Wright, you can step out, please, ma'am. Yes, sir. Bring him in for a second, please. Yes, ma'am. Thank you, Ms. Wright. Sherra, good morning, sir.
Good morning, young sir.
I apologize, did not know you were invited. July 12th is the day for you for report.
I apologize, I couldn't hear you.
I'm sorry, July 12th. Is that a good day for you for report setting?
May I check just a moment?
Yes, sir. I did not know you were invited. Ms. Turner, otherwise I would ask you to step out before I gave the other lawyers that day.
That's no problem. Your Honor,
Yes, sir.
July 12th is the second Thursday of the month, and I won't be available that day, but can I?
Ask
Any other day?
Ask Mr. Dallin, Mr. Reese, step back out, please, sir. Dallin, Mr. Reese. Ms. Perry indicates that July 12th is not a good day for him, so I need to change the date for Ms. Wright. What day would be a better date, Mr. Perry?
Also, it's supposed to be 11, July 11th, which is a Wednesday.
I'm good.
And that's for report setting only?
Yes, sir.
Yes, sir.
Because we should probably be in trial on the first degree murder case that week, so we'll take the announcement early on July 11th. But we should be in trial on the defendant first degree murder case that week. We'll change the date to Wednesday morning, July 11th for report setting. Ms. Perry, Mr. Ballin, Mr. Reese, Mr. Hageman, Mr. Schofield, thank you all.
Thank you.
Ms. Turner, I'll see you back in court on July 11th, sir. Thank you, sir.
Y'all be excused, Your Honor.
Yes, sir, thank you. Call the court to recess 2 minutes. Everyone can remain seated.
Court stands in recess.